सेव किया था ना?
मैं सिर्फ इसलिए गया था क्योंकि उसने मुझे कॉल किया, that's it. But listen though.
Save it for someone else.
जिंदगी में सेव करना जरूरी है, मगर जब बात पैसों की हो, सिर्फ सेविंग से काम नहीं चलेगा। इक्विटी म्यूचुअल फंड्स में इन्वेस्ट कीजिए और अपने सेविंग्स को आगे बढ़ने का मौका दीजिए।
Mutual fund investments are subject to market risks. Read all scheme-related documents carefully.
14th February 2012, as the country was celebrating Children's Day, the government brought in a landmark legislation to protect children from sexual offences. The Protection of Children from Sexual Offences Act 2012 not just protects children from sexual offences like sexual harassment, child pornography, sexual assault, but also protects their interests by bringing in more child-friendly practices within the courtroom, within the police stations, during investigations, and also by expediting the entire process through fast-track courts. And this is a law that we'll be talking about and discussing in today's episode of Laws of the Land. You have me, Apoorva Mandhani, you have Bhadra, Sinha, and we have with us today Professor Avaantika Chawla, who's an assistant professor at Jindal Global Law School. To tell you a bit about Avaantika, she holds an advanced LLM in International Children's Law from Leiden University at Jindal as well. Along with her core teaching responsibilities, she takes an elective on child sexual abuse and law. She's also the assistant director of the Child Rights Clinic, which undertakes research and advocacy work along with helping child rights organizations with their day-to-day work. So as you can see, she is the best person to talk to you and tell you more about this law. Thank you so much for joining us, Avaantika.
So Avaantika, the first question is that why was the need felt to have a special law for children? So what was the objective and the aim behind introducing this new legislation, especially at a time when we have a section in the Indian Penal Code to deal with sexual assault?
Right, absolutely. I think this whole process actually started way back in the early 1990s, and that's with the Freddie Pete's case. So I'm not sure how many people may know about the case. But essentially it was quite a sensational case that happened in a childcare institution in Goa, wherein there was a person of German descent. His name was Freddie Peets. He was sexually assaulting the boys at his so-called Gurukul, right? And he was also at the same time pimping them out to other foreigners. So this case shook the nation and specifically the state, right? And this led to, in 2003, the Goa Children's Act being enacted, which was specifically for the state of Goa, and it was the first legislation of its kind to deal with child sexual abuse specifically, rather than more of a general form of abuse as we see in the IPC. Right? And the 2007 study by the Ministry of Women and Child Development, which happened because of a lot of push by civil society organizations like Huck, in fact, which is based in Delhi, right? And the study showed that over 50% of children have been sexually abused. And it was very jarring because I don't think anyone expected these numbers, right? And it also showed that only 0.012% has actually been reported. So the process started in the 90s. We have the Goa Children's Act that came in. Then we have the MWCD study that came in, which then culminated in a bill that came about in 2009 to deal with violence against children, right? But again, civil society organizations felt that the bill was quite wide and we did need something to specifically deal with child sexual abuse. Coming to the IPC was considered to be inadequate in many ways, did not specifically deal with children, and most importantly was not gender neutral, right? If we only had 377, everything else we did not have. And also there were no specific laws on pornography and sexual harassment to the extent that the POCSO deals with it, right?
So, so when we talk about this act, can you just cite some specific provisions of the act that are actually that can be determined as acts or crime, as criminal acts? So like if we talk about sexual assault, so how exactly is sexual assault defined in POCSO law? How is it different from that under the rape provision of Indian Penal Code.
Right, of course. So the way that the POCSO deals with it is, it deals with it in a very progressive manner, right? So rape is obviously just one aspect. You have 375, 376, the punishment, and all of the other sections that flow from there, right? Under the POCSO, as the corollary, you have something called penetrative sexual assault, right? Which deals with any penetration that occurs. And just like the IPC, of course, it deals with penetration into any part of the body, including the urethra, the penis, the mouth, and also manipulation as more of a catch-hold. And then there is an aggravated form called aggravated penetrative sexual assault, which deals with more severe cases. The differentiation being that when it comes to persons who are perpetrating the abuse, right? For example, as we may know, most sexual abuse cases or most child sex abuse is perpetrated by family members. They are cases of incest. So all of those kind of come under aggravated penetrative sexual assault, right? And you also have other things like if the victim is impregnated, if the victim ends up catching a STD. So all of those things are also mentioned there. Then the second major category is sexual assault and similarly aggravated sexual assault, right? Which is more along the lines of what your 354 ABCD deal with, right? So that's more along those lines. And in that ambit, you have anything from touching off the so-called private parts to any part of the body, right? Okay. So that includes even if a child's waist is touched with a sexual intent, it goes there. And then we have sexual harassment, more of a catch-all for stalking, voyeurism, etc. And then you have pornography. So those are sort of the major categories of offences that we have.
So as Apoorva pointed out, the law also provides for child-friendly procedures. So if you could just explain a little bit as to, the kind of provisions that are there in the law and how that could be a follow-up question. I'll ask that later once you just explain this part of it.
Because even within courts can be really daunting even for adults. Yeah. So, and even police stations, I think there's a lot of hesitance there among people generally. So how does it protect children in those cases?
Right. So actually that way the POCSO is pretty well equipped. Implementation is another story.
Okay. That's why I didn't ask you the follow-up question.
All right. Let's talk about what actually exists in terms of provisions.
Yes.
So provisions are provided from everywhere, from the child actually making first contact with the police. For example, when a child's statement is being recorded, it's supposed to be done in a place that's comfortable for the child, right? So at the child's home or in a place or any place that is convenient for the child and their family. The child is ideally not supposed to go to the police station at all. Does that really happen? We will come to later. But then the child is supposed to be given frequent breaks. There is also provision for special educators, translators, etc. to be provided if required, right? This is when it comes to just when we are talking about the communication of the child with the police officers, right? And again, police officers are supposed to maintain confidentiality, which means ideally they should not be going to the child's house in, their police uniform. They should be going in plain clothes, which borrows a little bit from the Juvenile Justice Act. But anyway, at the court stage, something quite revolutionary that the POCSO did was set up special courts with special public prosecutors. So what that means is that in each court complex, right, which is with each district, they're supposed to have a special court that is solely supposed to be dedicated to POCSO cases. And within this court, you're supposed to have a special public prosecutor who is again only supposed to deal with POCSO cases, right? And the entire trial period is not supposed to be more than 1 year, but that's obviously not happening, right? And in addition to that, we also have child-friendly deposition mechanisms. There's a provision of a vulnerable witness deposition complex, right? When essentially at no point of time the child is supposed to come in contact with the accused. All questions to the child, whether by the public prosecutor or by the defense counsel, are all supposed to be put through the judge. And frequent breaks are supposed to be allowed, again, special educators, translators. So there is a whole plethora of measures that have been put in.
But since now you've mentioned a couple of times that in a lot of these cases, the perpetrator is or the accused is from within the family. How does the law protect the child in such cases?
I think like that's one of the fallacies of the law, right?
Okay.
Like I don't think while making the law, they fully realized the fact that most of these perpetrators are going to be from within the family, right? For example, even for me, I have also been sexually abused as a child, but by someone in my family. Now, in such a situation, I mean, I don't think it's fully possible to protect the child. Right? So now what ends up happening is when these cases are getting reported, seldom times it's the father who is the accused, right? In fact, a Huck study recently showed that quite a few of their cases, I think it was about 13% of the case that they worked on, the father was the accused in the case, right? And I've seen this even in my experience. In these cases, the mother is very hesitant to report, obviously, because, fathers are usually the sole bread earners, and it comes with a whole bunch of societal implications, right? So what we see happening is that the case gets reported, right? One of two things will happen. One thing that will definitely happen is the child will get put into a childcare institution, right? By the Child Welfare Committee. So now the Child Welfare Committee is a committee that has been set up under the Juvenile Justice Act, right? Whenever there is a child who has been sexually abused, and also other categories of children like child laborers, runaway children, they're to be produced in front of the Child Welfare Committee, the CWC. Now, when they're produced before the CWC, they will immediately send them to a childcare institution, right? Because it's an incest case, there's high likelihood that the child can turn hostile, right? So the child remains in the childcare institution a lot of the times till the child's testimony is done, right? Which is quite problematic. It is no place for a child to grow up, and testimony can take anywhere between 1 to 1.5 years at times,
And
right?
the status such institutions as well
is quite pathetic most of the times, until unless it's private run, right? Even in those circumstances, it's debatable. However, a lot of the times the child is unhappy in the institution. They beg to go home. Once they beg to go home, they're home, right? And then the mother is putting pressure on the child, right? I'm not saying there aren't a lot of strong women out there who are really fighting for their children, but most times they're not. If you look at it practically, the socioeconomic status is really bad, and whatever compensation benefits are there, they're not going to last a lifetime. Right? So I don't think the POCSO has taken those things into account, right? And which is also one of the issues with mandatory reporting under POCSO.
I was about to ask you that question, because it is compulsory to report a POCSO case, isn't it? There is a compulsion. So then, despite there being this provision, still, we are facing these kind of issues and problems.
But that's the thing, right? Again, I don't feel like this has really been taken into account. Now, since we've spoken about mandatory reporting, it is something that's punishable, right? It is 6 months to 1 year for anyone. Obviously, it does not apply to children, but it's 6 months for persons in general, and 1 year for heads of institutions, right? So now, mother in such a circumstance, if she does not actually report it and say the child leaves the house and goes to report it, the mother also is made an accused.
Right.
And then where is the child and what is the child left with in that situation? And in those situations, you will see, of course, the child in most circumstances will turn hostile. Right? Because, in my experience in working with children, what I've realized is, for them, their main concern is for the abuse to stop. Right? Their concern is not about, and the family dynamics that are involved are very different, because the child has so much conflict. On one side, they want the abuse to stop. But on the other side, they also love their parent or whoever relative or whoever may be involved in the case. So I think
emotional attachment.
Yeah, there really is. And there's this 164 statement, which is a statement to the magistrate, that I still remember. The child said in her statement, "I don't want my father to leave me. He's a very good father, but he hurts me sometimes. Please make him stop hurting me." So what I'm saying is, like, those are the kind of implications that you're facing, and the law is not equipped to deal with it at this time. I think we do need better guidelines, etc., to come in place to deal with incest cases.
Right.
This law is generally, spoken as a very stringent law. If you could just explain a little bit around that, why is it supposed to be stringent? What are the sections in the law that make it stringent?
Right, it's stringent because of the minimum punishments that are in place, right? The minimum punishments range from 10 years to 20 years to 7 years, right? Okay. So it's the minimum punishments which are very strong, but at the same time that also has its implications, such as in cases of incest or in cases where two adolescents may have indulged in consensual sexual activity, right? So now if there's a 17-year-old and an 18-year-old who have decided to run away and together and have had sex and the girl is pregnant, that's a sure shot conviction because it will be a DNA match. And then what are you going to do?
So that's actually an ongoing debate that I think we should talk about, because the Chief Justice also, Justice Chandrachud also recently spoke about how there needs to be a relook at maybe the age of consent. You know, there are a lot of these consensual relationships between teenagers that are now coming up before courts. So could you tell our viewers a bit about that?
Sure. So there are two categories of cases even when we look at consensual sex. The one is adolescent within adolescent. So say it's a 16-year-old with a 17-year-old, right? That is one category. And then the other category is, and that category being that both are children essentially, other category being when there is one person who is a child, as in under the age of 18, and the other person is an adult. Let's talk about the first category because that has a little bit of more room for the judiciary to deal with it, right? So now here what happens is, in most instances you will see, even though the child or the girl, right, firstly the case has gotten registered because either the girl's parents would have said that, you know, my child has run away from home, or a lot of the times you see that the girl's family does not approve of the boy, so they go ahead and register the complaint, right? Now in this circumstance, the boy is the one who's mostly made the accused. And I say this even when the girl says very clearly that this was consensual, the boy is still made the accused. I'll give you all an example of this, although it is not consent really, but there was this one child who had been sexually abused by her neighbor, right? Okay. And because of that, she wanted to experiment, which is a very natural biological reaction, which a lot of people don't understand, but it is, right? So she decided to experiment with her brother. Now, and as a result of the abuse that she had suffered because of her neighbor and the activity with her brother, she ended up impregnated, right? And it turned out after DNA testing that the child was in fact the brother's child. Now, in this case, even though the child said that no, I forced myself on my brother, the brother still made the accused. Right. Although we don't use the word accused when we talk about children under the age of 18, we use the word children in conflict with the law. So now here what happens is you have usually the boy who becomes the child in conflict with the law, although as per the provisions of the Juvenile Justice Act, because such instances would be dealt with under the provisions of the Juvenile Justice Act, such cases would not be in an adult court, they would be before the Juvenile Justice Board. What technically ends up happening is that both children are technically, at least, children in conflict with the law as well as children in need of care and protection, right? So because there is no person who's the wrongdoer as such in this case, right? Now under the Juvenile Justice Act, there's a lot of wiggle room, right? They can simply say, okay, this child should be sent for counseling, done and over with. All right, quite easy there, you know, despite the fallacies of the act, still easier to deal with. Now the other category is where things get complicated because it's possible that if there is a larger age gap, it could be a case of grooming, right? You can't rule that out.
Yes.
If the age gap is lesser, and especially if the child has said, you know, in her testimony that they did in fact have sex, or the child ends up impregnated, it's a sure shot conviction. There is no wiggle room because the minimum punishment is what it is. And for aggravated penetrative sexual assault, which would be the case if the child ends up pregnant, is a minimum of 20 years. So what are you going to do in that case? The court they're at an impasse. And we see high courts across India now circumventing the law.
Right.
Because that's not justice.
Right. So the aspect of consent in POCSO, I mean, even if a girl says that I consented to this relationship, it has no relevance.
There is nothing called consent under POCSO. We don't have a concept of consent under POCSO. If you are under the age of 18, you cannot consent.
Right. So that probably is the reason why in a recent judgment the Kerala High Court had said that, you know, the teenagers need to be educated about this act, right? So are there any programs that have been undertaken by NGO, civil society or the government to educate the teenagers about this law or not?
Right. I mean, I think there are a lot of ongoing efforts, especially by civil society organizations, wherein, you know, they are working on sex education, and a part of the sex education is also educating children about consent. For example, even at Jindal, as you said, I run the child rights clinic at Jindal, and right now we're creating a child-friendly primer on child sexual abuse. So part of the primer also deals with the fact that, hey, the age of consent is at 18. So know that before you enter into sexual activities that you're not in a soup. Which is really sad because, I mean, adolescent sexuality and hormones are so normal. But I think just the incessant need of the state to control women's and children's sexuality it leaves us where we're at.
Right.
But, you know, POCSO is now, we've come across in many cases, also now, you know, is being seen in conflict with some old, I mean, I won't say, but, you know, the social rules, old cultural, traditional social rules where, you know, marriages are still happening, minor marriages are still happening, maybe in some tribal communities. So, but these marriages are continuing, you know. So either they are ignored about the law or they are willingly violating it. So, I mean, in such a scenario, how does one really deal with these cases? Because now the number of such cases entering the courts is really increasing. And I think, and not just in a specific court, but across the country. And it's reached the Supreme Court as well. So, what solution do you see in this kind of a situation?
I think that there is a need to relook at the law, which is what the Supreme Court has also said recently, because you cannot ignore what the on-ground reality is. I'm not saying that we should not encourage societal change. That is not what I'm saying. But at the same time, you cannot ignore societal reality. You need to stop and take a look at whether the law is causing more harm at this point, right? I think what you're referring to, I'm assuming, is probably the plethora of judgments that have come around Muslim personal law and 15 years being considered to be a reasonable age at which a woman...
There are a couple of judgments even from the Meghalaya High Court, and most of them are primarily related to certain tribal communities, you know, where marriages are still between minors are still taking place. And in those cases, the biggest problem which, you know, they faced is that the hospitals refused to treat the woman who got pregnant out of this relationship, you know, and she went there. In all the cases, you know, the women went to the hospital and they were just looking for regular treatment. But the hospital went ahead and complained to the police and they said, sorry, we cannot treat you. So, and it was like a double whammy for them. So they were facing a police case, and on top of that, the woman who's pregnant was denied medical treatment and medical care, you know. So in such cases, this law is becoming a stumbling block.
Yeah, it definitely is. In fact, it's not recent, but that was a 2018 Meghalaya High Court judgment wherein they spoke exactly to this. And in that case, the court said that we will acquit him because it's not justice. And it was the exact same situation that you're talking about, wherein a woman was impregnated, and as a result of a marriage between a 17, I think, and an 18.
Yeah, it's usually 17, 18. The girls are aged between 17 and 18.
Precisely. And the case had to be reported because of mandatory reporting. So you see, all of these things are very much tied in together. I mean, you can't look at any of them in isolation. And of course, mandatory reporting also does, to some extent or to a large extent, impede on an adolescent's right to sexual health as well and to reproductive rights.
Yeah, so this issue has come up before the Delhi High Court, where mother of a minor girl has challenged this section.
Section 19,
Yeah, precisely. Because I think, and it should be challenged, because I feel like there is a need to relook at what is the implication of the law, right? And there have been so many reports out there because it's been 10 years since POCSO. And all of these reports have mentioned these fallacies. So I would hope that we would relook at the law, right? And if we actually look at it, we're only talking about, when children or when a child gets impregnated. But actually mandatory reporting technically also impedes their rights to contraception. Yes. Because technically, if I was say 17 and I were to go to you, say, or to a doctor and be like, hey, I'm having sex with my boyfriend, I am about to have sex with my boyfriend or girlfriend, whoever, I would require contraception. Section 19 says that you're supposed to report not only offences that have happened, but if you suspect that an offence may occur. So you're not only impeding an adolescent's right to reproductive health services as an abortion, but also to contraception. So it is a much larger issue that we do need to look at. And when we look at mandatory reporting specifically, countries around the world usually have a stakeholder-specific mandatory reporting, which is that persons who are working in close proximity with children are required to report, right?
Okay, that's the difference.
Yeah. However, here we have universal mandatory reporting, which means that everyone must report.
Yeah.
So now, since you've spoken about the provisions of the law that maybe need a relook, let's just talk about implementation as well. Now, of course, we had special courts that were designated to, look at these cases. But these were the courts that were designated, look at them. There were no new courts formed. And essentially, if you go to see, or maybe if the new courts are formed as well, if you go to see, the people handling these cases are essentially the same people, right, in the system. Is there enough sensitization that's happening for them to deal with these cases involving children a little differently? Are there other stakeholders involved? Are there support people involved? What is the situation on that front?
Right. So I think we all know about the recent Supreme Court judgment, which saw that there were barely any vulnerable witness deposition complexes, and it was ordered then that all High Court Juvenile Justice Committees must ensure that VWDCs are established, right? So we already know about that based on what has already come before the court, right? And similarly, we have also found that it was in 96% of POCSO cases, no support persons have been given, right?
If you could tell our viewers a bit about vulnerable witness deposition, this thing also, and support persons.
Sure. So vulnerable witness deposition complexes are essentially, it forms a part of a couple of rooms, right? So in those complexes, you firstly have a child-friendly waiting room, right? Wherein you would have the child come in through a separate entrance, which is not directly, attached to the court, because you want to ensure that the child feels safe, is not intimidated, and definitely does not come in contact with the accused, right? So the child will be brought in through a different entrance. They would be placed in a child-friendly waiting room, right? And these child-friendly waiting rooms are supposed to have games and things like that, right? In them to keep the child sort of
preoccupied and properly,
right?
In a relaxed state of mind.
Precisely. And they provided food there, etc. And then as far as the courtroom is concerned, what you have two separate rooms. Right. So there is, your child's testimony would not happen in a regular courtroom, which would be the special courtroom. It would happen in this separate room, right? In one room, you would have the judge along with the court staff, the lawyers, right? Both the victim's lawyers, the public prosecutor, as well as defense counsel sitting, as well as the accused. Then you have another room wherein you have the child sit with a support person, right? And both of these rooms are connected both via video as well as audio, right? So whatever the questions will be put up to the judge. The judge will in turn adjudge if the question is appropriate, put it up to the support person in the other room who would hear whatever the judge is saying via their earphones, right? They would then relay this question to the child. Whatever the child says will be heard directly in the courtroom. Okay. So it's sort of like an audio-visual link which is created to ensure that there's minimum there's minimum contact of the child with persons in the justice system as well.
But what about the implementation now? That's what you were telling us about. Huh?
So the implementation, I think the Supreme Court already knows the reality, right? Is that there aren't too many of them, right? Yeah. Now the thing is that if I look at Delhi, because this is where I have practiced, the pendency is very high and the vulnerable witness rooms are on most days were not enough, right? Even though, say, for Saket, you have two vulnerable witness rooms because you have South and Southeast district there, right? Now, there were times when our children and we've gone to court and they were like, sorry, the child has to go back. The vulnerable witness room is not available. Right? So it also leads to the child having to come back to the courtroom over and over again. But this is a rosy situation wherein you actually have a vulnerable witness room. Then you have a lot of other courts, wherein testimony is still happening in the old-fashioned way. The accused are standing right here. There's a little wooden divider, which actually means nothing. Child will be sitting here, defense counsel will be sitting here, screaming at the child. Right. For example, and I'm saying this was in a court in Delhi. Vulnerable witness room was only one. So that room was busy. So they were like, it's fine, we will just have the child's testimony in the regular courtroom. Now, as per the POCSO, all questions are supposed to be put to the judge and then the judge puts them up to the child. But how can that be done when the defense counsel is standing next to you, right? It's not possible. So that is the reality. The reality is most court complexes don't have it. If they have them, they're not sufficient, right? And that's where we're at. And it leads to a lot of re-traumatization for the child because a lot of the times the questions being asked are irrelevant, For example, in one case, we had the defense counsel trying to question that the child's father is not actually her father. How is this related to the case? No one knows, right? And the judge in a vulnerable witness room could have disallowed that question, or us as counsels for victims could have opposed to the question. But in an open courtroom, what can you do? The child has already heard the question. So it's a very pathetic situation.
So when you see the data of the last 10 years, ever since POCSO actually came into existence, has there been an increase in reporting of such cases?
For sure. I think NCRB data already shows that this is not something that we even need to wonder about. There has definitely been an increased reported cases.
So does it mean that there is people are aware of it, aware of the law? Does it mean that, or is it that that they're being forced to report? How do you see the situation?
So actually there was a study by the CCR Center at NLSIU Bangalore, right? And they actually showed that mandatory reporting was not, in terms of, strangers at least reporting, very high. We can't say now in terms of parents, schools or teachers reporting whether it was mandatory reporting or whether they actually wanted to report it. So I don't think there is a way to differentiate between the two, but I definitely do think there has been increased awareness since POCSO came in. And there have been a lot of government efforts, civil society organization efforts to get reporting happening. So you can see that happen. So I would say when we see high reporting, we shouldn't be alarmed. Right. We should think of it as a good thing. People are coming to the fore.
And what about the conviction or the acquittal rate?
So I think there was Vidhi just released a study on this, right? I think, and if I'm not wrong, the figures were for every 3 acquittals, there is 1 conviction, right? Right. But now, why are these convictions so low? A large part of it is because of everything we've just discussed, victims are turning, large part because of infrastructural issues, etc.
Or probably because the majority of these cases, as we say, are related to incestual.
Yeah, I was just coming to that. A part of it is incest cases wherein children may be turning hostile. And a large part of it is also, infrastructural issues. Like your forensic report not coming in time. There is a huge...
So whatever plagues the criminal justice system generally also then applies here.
And then then you have more layers to it, right? A lot of the acquittals may also be happening because there is a so-called romantic or consensual angle in the case, right? So I don't think we have enough, or we haven't studied this enough to see what is the reason for the acquittal. Right. However, in my experience, what I've seen is that acquittals, at least in cases when the child has been abused and there was no angle of consent, I would say the reasons have mostly landed up to investigation, right? Investigation not having been done properly. And the second major reason is minor inconsistencies in the child's statement, right? And that would happen anyway, because now if the offense, I had a kid, offense happened in 2016, Testimony is happening in 2020. I mean, what are you expecting here? There will be minor contradictions, and we all know there is more than enough Supreme Court judgments on this aspect.
Right.
But it's clearly not trickling down. And then how many of these cases are actually being appealed? Right?
That is another question actually.
Yeah, how many of these cases are actually going into appeal?
Right.
If the child does not have direct legal representation, then it's very unlikely that the state will actually appeal the case. Until unless it was a very strong case, right? But now for us as representatives of victims, we would always want to appeal the case, right? If we feel like there is something there and we have enough to appeal it, we will. But the state is not going to relook at every case in that way, right? And that also kind of circles back to what you were talking about, people in these special courts, right? Now, when you're dealing with such cases, and especially with children, ideally you would want the special public prosecutor to interact with the child, know what are the issues that the child is facing, right? For example, I had this one case where the child developed selective mutism, right, which was as a result of the PTSD of the sodomy that happened. Now, there was no way for the public prosecutor to know that the child has selective mutism, so he's not going to be able to testify, right? If I weren't there as the child's legal representative and I would not have gone to the court and told them the situation and, then the judge met the child, etc., how would they have known that this is what is happening? They would have instead been putting pressure on the child to speak, not realizing what the child is actually going through. And I don't blame it on them. The number of cases is so high. How can you expect that kind of interaction? So we really do need more of support persons who are essentially persons or organizations that are appointed by the Child Welfare Committee to help the child and their family through the entire trial process.
Right. Just wanted to ask a question. The Child Welfare Committee, can you just expand this committee's role in terms of POCSO?
Sure. So the Child Welfare Committee, as I told you, has been formed under the Juvenile Justice Act, right? Yeah. So the role of the committee under the ambit of the under the ambit of the Juvenile Justice Act is the same as that for POCSO cases. The role remains the same, but I'll contextualize it a little bit. So whenever a POCSO case is reported, the child has to be produced in front of the Child Welfare Committee. The Child Welfare Committee will then assess the needs of the child, right? So if the child is in need of counseling, the child needs to be placed in a childcare institution. If there are any, educational needs that the child may have, any psychological needs, right? So then all of those directions are then passed by this quasi-judicial body, that's the Child Welfare Committee. Okay. So their role is essentially to ensure that all of the child's psychosocial needs are being met.
Basically to look after the child, the victim, the child victim. Yeah. But tell me one thing, that, do we really have trained counselors to deal with such kind of victims?
I think...
At least the ones who are associated to the Child Welfare Committee. I mean, you've come across practical cases, so you'll be able to throw more light on it.
Unfortunately, no. I feel like a lot of the members, I can't generalize.
No, we are not. Of course.
That's okay.
A lot of the members are not trained in the way that... they have very archaic beliefs. They're not rooted in today, right? For example, I had gone to the Child Welfare Committee in a district in Haryana because planning to start something there, and went and I spoke to them. Firstly, there's supposed to be 5 members. Only 2 members were present. The other 3 have not even, their term ended and new members have not been put in place, right? Now we were talking about consensual cases, right? And they said, most of these cases are consensual cases. These girls have no control on them. So you get what I mean? Like those kind of notions that they have, those really need to be unlearned, And obviously I'm not saying that trainings will fix all of it. Right. But at least in the way that you do need to train these people to be more sensitive. And the thing is that the JJ does say that all of these people need to come with experience in working with children. But then what is the quality of that experience, Where, what is that, what field is that experience in that it's coming from? Right. So those are some things that should also, in my opinion, be looked at. But then again, we also have a lot of CWC members who are absolutely amazing, and they work day and night to make sure that the child is getting everything that they need. But unfortunately, I would say most of them don't.
So there aren't enough
such people. because and the ones who are there, I mean, they are working tirelessly to to support children in any way that they can.
Right. So there is awareness. There is enough awareness. It has grown since the law was brought in 2012. But as you might have heard Avaantika say, there's still a lot that can be done. There's maybe time for a relook at the act, the way it's being implemented on the ground, and how to make the law more child friendly. I hope you enjoyed the show. Thank you so much for joining us, Avaantika. Thank you so much for making time for us. Do let us know in the comment section what you thought about this episode, and like I've told you before, if you have any law that you want to know more about, do tell us in the comment section and we'll try our best to take them up in the next few episodes. Thank you so much for joining us.